In 1522, the city of Autun in France had a problem. Rats were destroying the local barley crop, so officials did something that sounds completely ridiculous today. They summoned the rats to court, and when the rats failed to appear, their lawyer stepped in with an argument so clever that the case became one of history's strangest animal trials. The charge against the rats was simple. They were destroying barley crops around Autun in the Burgundy region of France. Today, somebody would probably put down traps, bring in pest control, and get on with it. But in the early 1500s, there was another option: take the rats to court. A formal complaint was made, and the case went before an ecclesiastical court, basically a church court. The accused were then ordered to appear. Not the farmers, not the landowners, the rats. As strange as that sounds, this was not some one-off bit of medieval madness. Animals really did end up in court in parts of Europe. Domestic animals such as pigs, horses, and cattle could be prosecuted when they injured or killed someone. Rats, mice, insects, and other pests were a little different. When they damaged crops or overran an area, cases against them could be handled through church courts, and these proceedings could be surprisingly formal. There were judges, there were summonses, there were legal arguments, and sometimes there were lawyers, which left the rats of Autun needing someone to defend them. Their lawyer was Barthélemy de Chasseneuz, and he was not a village nobody playing along with a ridiculous court case. Chasseneuz was a genuine French lawyer who went on to have a very successful legal career, eventually becoming a senior judge. But defending rats came with an obvious problem. His clients were not exactly going to sit beside him in court and explain their side of the story. The barley was being eaten, the rats were being blamed, and none of them had bothered to turn up. So Chasseneuz went after the procedure instead. The court had summoned the rats. But which rats? There were rats spread across the surrounding area, living in different villages and parishes. Chasseneuz argued that if all of them were being accused, then all of them had to be properly notified. One summons was not enough, and the court agreed. A new citation was ordered, with notice to be announced more widely so that the accused rats had a proper chance to hear about their court date. Yes, a court effectively decided that the rats had not been given enough notice, so the authorities tried again. Another summons went out, another court date arrived, and once again, not a single rat appeared. Now, Chasseneuz had a harder problem. This time, the rats had been properly summoned. They still had not shown up. So why should the court give them another chance? Chasseneuz came back with an argument that was even better than the first. The rats could not safely get to court. They were scattered across the countryside, and reaching Autun meant travelling through territory full of something rats had very good reason to fear: cats. According to the argument, the journey itself put the defendants in danger, and Chasseneuz's point was that a defendant should not be punished for failing to appear if getting to court could get them killed. That sounds hilarious when the defendants are rats, but legally it put the court in an awkward position. The court wanted to treat these animals as defendants. Chasseneuz was basically saying, fine, then treat them like defendants. You cannot demand that they follow the law while ignoring the protections that come with it. And that is why this case became famous. Chasseneuz was not trying to prove that the rats had never touched a barley. He was using the court's own rules to make the prosecution much harder. Of course, there is still a much bigger question. Why was anyone doing this in the first place? Why hold a court case against an animal that cannot understand the charge, speak to its lawyer, or even know that a court exists? There is no single answer. For people living hundreds of years ago, law, religion, and the natural world could overlap in ways that seem very strange to us now. If a pig attacked someone, the pig could actually be captured. It could be locked up. It could be physically brought before a court. Rats and insects were another matter. You could not arrest every rat in Burgundy. So when large numbers of pests damaged crops, communities sometimes turned to church courts instead. The animals might be ordered to leave an area, and religious penalties could be threatened if they stayed. To us, that sounds pointless, but imagine living in a farming community where your food supply is being destroyed and there is very little you can do about it. There are no modern pesticides, no professional pest control company is coming, and if the crop fails badly enough, people may go hungry. A formal court proceeding at least gave the community a way to respond to something that otherwise seemed completely beyond its control. Religion was part of it. Law was part of it. Fear probably was too. And we should be careful about reducing the whole thing to people back then were stupid. They were working within a very different understanding of how the world worked. Chasseneuz himself certainly took the legal questions seriously. Years later, he wrote about cases involving destructive animals and insects, including whether they could legally be summoned, who could represent them, and what kind of court had authority over them. So the rats of Autun were not just a punchline to one strange court case, there was an actual legal debate behind it. And once you start looking into animal trials, the rats almost seem normal. Almost. Pigs were probably the most notorious defendants. If a pig seriously injured or killed someone, it could be arrested, held, tried, and even executed. One famous case from France involved a sow accused of killing a child. Another case in 1457 involved a sow and her piglets after the death of a young boy. The sow was condemned, the piglets were not. There was not enough evidence to prove that they had taken part, which is a remarkable detail. Even in a prosecution involving pigs, the court was apparently still asking, can we actually prove which ones did it? I have covered the pig trials in detail, which is linked below. And the list of animal defendants went well beyond pigs and rats. Historical accounts describe cases involving cattle, horses, dogs, mice, insects, and other creatures. Some were accused of attacking people, others were accused of destroying crops. So by the time Chasseneuz stood up for the rats of Autun, he was working within a legal tradition that already existed. What made his defence memorable was how far he pushed the logic. If the court was serious about prosecuting rats, then it had to be serious about the rules as well. This is usually where the story gets a perfect ending. The clever lawyer defeats the court, the rats win, case closed. Unfortunately, history is not quite that tidy. The final judgment in the Autun case does not appear to have survived. One of the best known historical accounts was published in 1906 by E.P. Evans, who collected examples of animals being prosecuted across Europe. When Evans discussed the rats of Autun, he noted that the final sentence was not recorded in the source available to him. That creates a problem with some of the versions told today. You will sometimes hear that Chasseneuz completely defeated the prosecution, or that the court gave up because it could not guarantee the rats safe passage. Maybe. It certainly makes a great ending, but we do not actually have a surviving judgment that lets us say that with confidence. What we can say is that animal trials were real. Chasseneuz was real. He became associated with the defence of the Autun rats, and the arguments involving proper notice and the danger posed by cats became part of the story handed down through legal history. What happened when the court finally had to decide the case? That part is missing, which, strangely enough, might be the most appropriate ending possible. 500 years later, the evidence still is not good enough to convict the rats. So, why do these rats need a lawyer? Because once the authorities decided to treat them like legal defendants, they created a problem for themselves. Defendants had rights. They had to be properly summoned. They could be represented. And Chasseneuz argued that they could not reasonably be expected to travel to court while their lives were in danger, even if that danger happened to have 4 paws and a taste for rats. And before we close the file, if you enjoy these strange cases where animals somehow end up tangled in human law, give the video a like. It helps more people find the channel. So, the final findings? Animal trials in Europe? Confirmed. Animals really were prosecuted in both secular and church courts. The Autun rats received a legal defence? Confirmed. The case became famous for Chasseneuz's arguments over the summons and the danger the rats faced getting to court. But the rats won the case? Inconclusive. That is how the story is sometimes told. But the surviving account does not give us a clear final judgment. So we know the accusation, we know the defence, we know the lawyer, we even know why the defendants claimed they could not come to court. But after more than 500 years, we still cannot prove the rats were guilty. And if you think giving rats their own lawyer was strange, wait until you see what happened when a medieval court put a pig on trial for murder.